I'm going to introduce Rupalee. Rupalee Rashatwar is here to speak to us about compassionate release. She's a staff attorney at the ALC based in Philadelphia. She received a JD from American University at the Washington College of Law. She received a degree in public interest, public service scholar. She also received her BA from George Washington University. She interned various organizations, including Community Legal Services, Capital Habeas Corpus Unit at the Federal Defender of the Eastern District of Pennsylvania, the American Civil Liberties Union of DC, and the Public Defender Service of DC prior to joining ALC. Rupalee was a public defender at the Office of Miami-Dade Public Defender for several years, where she represented individuals facing misdemeanors, felonies, juvenile charges. At ALC, Rupalee engages in post-conviction, class action, and civil rights litigation on issues ranging from solitary confinement to compassionate release. Rupalee is licensed to practice law in Pennsylvania and Florida. And with no further ado, take it away.
Thanks for that kind introduction, Chris. I appreciate it. And thank you guys all for having me and making some space to talk about compassionate release, or really the lack of compassion in the state statute in Pennsylvania. I recognize a number of names of individuals who are in this group as people who have collaborated in various ways. And so I suspect there's a lot of knowledge collectively in this Zoom meeting. And so as we go along, if anybody has questions, feel free to put them in the chat. I'm happy to take diversions and sort of answer what may be on anyone's mind. And for a lot of names I don't know, I'll sort of go through what a general overview of the state statute is. And at the end, I'll leave some space for additional question and answers if there are any. I know we're slated to go for about a half hour, so I'll use up that time. And then if there's any questions at the end and folks want to stay on, we can use that. But with that, I'll just start by adding, besides the introduction that was given at the Abolitionist Law Center, we've done a number of compassionate release petitions over the last 2.5 years. Our work in this area was all sort of launched by, when we represented Russell Marin Shotes in a compassionate release petition and were able to bring him home to some of his family members when he was really sick. And sort of born out of that was this, what we realized was this real need for legal representation for individuals who are older and who are dying in Pennsylvania prisons. It's really the result of a lot of sentencing policies. And I think the one theme that's going to be really apparent throughout this whole presentation is really just what the law is and its shortcomings. So this is my cat. Will make an appearance from time to time, but I'm just going to go ahead and share my screen so we can go through some slides I have. Okay. So I hope everyone can see, but we're going to be talking about the medical transfer statute. It's actually not called compassionate release. It's called medical transfer 9777. And why this statute matters, I imagine it implicates some of the work for a lot of people who are in this Zoom, but it's really, we have a crisis in Pennsylvania prisons of an aging population. I think a result of a lot of the sentencing policies from the 70s and 80s and 90s are that we have a number of people who are aging and whose medical needs are absolutely not being adequately addressed by prisons. And I think most people here would probably agree, it really doesn't make any sense to keep our elders in prison. I mean, there's not reasons to keep many people in prison, probably most people. But I think particularly what we know about recidivism rates and what we know about older individuals, there's really not a lot of sense behind it. Compassionate release is a racial justice issue. And one thing to note is that most life sentences that were given out in Pennsylvania originated from Philadelphia. And I think finally, another really important point is that elders are needed in our communities to keep our community stronger. We need credible messengers. We need people who have experienced a lot of issues that resulted in their incarceration to make our community stronger, to support families, and to be present. I think a lot of when we think about a lot of what it means to age and to die in prison, there's really an enormous tax on families. So many families are prevented from being able to support their family members as they're sick, to advocate for them to get compassionate care, to be with them and to support them as they're aging. And so this law offers, one remedy, which is to permit people to transition either to a facility or to receive home hospice when they're at the end of life. As many of you here probably know, there's little dignity offered to those who are dying in prison. Anytime an individual is taken to an outside hospital in Pennsylvania, they're shackled. That's even if they're on a ventilator, even if they're in a coma. And creates a lot of problems for people, particularly if they need to be rotated, if they're on bed rest. A lot of people are not permitted to even have any family phone calls when they're at outside hospitals, which is incredibly difficult when a lot of times for people's actual medical success, they need a support network, they need access to their family members. We've just heard tons of horror stories of a lack of pain management for individuals who are in prison. A lot of individuals are just getting Tylenol and ibuprofen to treat their end of life diagnoses, and there's no licensed hospice providers in the state of Pennsylvania. So this is just a chart that was generated, you'll notice, 2 years ago, showing how few medical transfer petitions get filed. So this was published in April of 2022. So you'll notice the number in 2022, that doesn't actually reflect the number for, by the end of the year, but you'll notice it's extremely low. I mean, there's way more people than what's reflected on this chart who would have been eligible for compassionate release, but who never had a petition brought for them. And there's really a lot of reasons why these numbers are so low. Right now, ALC has brought, at least 15 cases in the last 2 years. So that's in addition to, another attorney who's practicing and a couple other attorneys we know of who are taking these cases. But so even if the numbers are a little bit higher now, they're still very low. And a lot of that's because, there's no right to counsel in cases like this. The Department of Corrections also, they don't bring these cases themselves, even though technically under the statute they could. There's a provision where it says the department could bring a case or petition to sentencing court for relief. And the Department of Corrections also doesn't affirmatively take any steps to assist to connect people to any actual medical providers, which are required under the statute to bring a petition. So, there's a lot of reasons. One of them is access to counsel. One of them is definitely finding providers where there's really not a stigma against treating folks who are formerly incarcerated. Also connecting people to facilities and finding facilities that are willing to make space for individuals who are going to receive Medicaid. And a lot of times it's because the statute is drafted so narrowly that many people they aren't ever really given the time or the diagnosis to say, you are terminally ill and you have X amount of time to live. A lot of times illnesses and sicknesses just come on a lot more quickly. And also people just aren't aware of the statute. So we're just going to talk a little bit about what the actual statute is. Before I'll get into that, like I mentioned before, this is a crisis. It's looming. I think many people are aware of it. And I think as time goes on, there's just going to continue to be so many older people who are in prison infirmaries, who are not getting the care and the dignity that they're really entitled to at the end of life. But this is really a result of so many sentencing policies. And like I mentioned before, if you just compare Philadelphia and the number of death by incarceration sentences coming out of Philadelphia, and you compare them to other states, I mean, it's enormous. Um, so I want to talk a little bit about what the actual statute says. And I notice I'm actually not able to look at the chat. So if anybody puts things in the chat, I might not see it. So I'll just check it periodically, or I'll sort of I'll let Chris chime in and let me know if there's a question in the chat that needs to get addressed. So I'm going to talk a little bit about the statute and how it's written. So there's two ways to petition for relief under the medical transfer statute, A1 and A2. So I'm going to start with A1. A1 says that someone has to be seriously ill and not expected to live for more than 1 year. The interesting thing about A1 is that it requires that someone be connected to a facility, meaning they can't go to a home placement or a family member's home to get care. It has to be at a hospital or long-term care facility. It doesn't say anything about someone's mobility. So someone could have the ability to walk and move around freely, but it requires that a person not have legal detainers. So for anyone who doesn't know what a detainer is, anytime you are so for individuals who are sentenced to a crime, they might have on their record a detainer. A detainer often comes from either the same county that they're sentenced in or a different jurisdiction, and usually it relates to another crime that they might have been convicted of. So it could also relate to immigration issues. So a lot of times what that'll mean is if somebody was incarcerated for maybe 20 or 30 years and they got a charge in another county where they were incarcerated, like Luzerne County, and they got an assault by an inmate charge or something like that, there might be a detainer on their record, which means they might not be able to apply for relief under A1. Interestingly, A1 doesn't say anything about hospice. It just says that someone has to be seriously ill, meaning a doctor thinks they're going to live for less than a year, but it doesn't necessarily mean that they have to be hospice eligible. So for anyone here who's not really familiar with hospice, hospice is care that's provided at the end of life. So for individuals who are no longer seeking curative care for whatever it is they might be diagnosed with, they're going to want to receive hospice care. It's care that treats symptoms like pain, like nausea, and it's palliative in nature. It's not care that's going to treat underlying disease. So that's available under A1. More treatment is available under A1. And I would contrast that with A2 for individuals under A2. Someone has to be eligible for hospice care. They have to be not ambulatory. They have to be likely to die in the near future. And there's nothing in A2 about detainers. So anyone can have detainers of any sort for them to apply under A2. So I want to talk a little bit about more appropriate medical care and what that means and the kinds of arguments we sort of make when bringing cases like this. Um, so like I mentioned before, Pennsylvania does not have any licensed hospice care providers within state prisons. A lot of their hospice units are run and they are staffed by other incarcerated individuals who don't have any medical training, who don't have any ability to prescribe medication or treat individuals' pain, but who are just there to give people company when they are very sick. Also, there's a lot of restrictions on how people are able to access care they need, wherever they might be. So, there are all kinds of rules and regulations that make it very difficult to manage your medical conditions when you're in prison. Like, if you require oxygen, sorry, somebody I think might need to mute themselves. I'm just going to go ahead and do it. So if individuals need oxygen, like they might have a COPD diagnosis, they're oftentimes not able to have oxygen on their unit in general population. They have to reside in the infirmary. Often the infirmary is so cold that it is like it is prohibitively unpleasant for older individuals who just aren't they aren't provided um, what they need to feel comfortable. Um, then there's all kinds of other things that present issues for individuals. Like they might need to get pushed a great distance to get their medication many times a day. Um, there's often not the ability to call for medical emergencies and for there to be immediate attention provided to them in case something might happen. Also, prisons just simply are not staffed to treat and to manage the needs of individuals who are very sick and who are elderly. They're oftentimes the way that their infirmaries are managing the care requests that are coming from other individuals who are incarcerated is they're doing it in the order that their requests are made. There might not necessarily be a triage way to treat certain people who have very urgent needs and who don't. And also, there's a lot of variation from one prison to the next. There are some that I think can manage this with different levels of skill than others. Um, yeah, and I'd also just mention a lot of times there's accessibility concerns about reaching the bathroom. Many people are incontinent and managing that through access to the bathroom, through access to a catheter, changing their catheter, diapers, whatever. I mean, it's prisons just really are not designed for any of that. I mean, I'm telling you all things that you know, but these are all the arguments that are really made in front of a judge. Um, I think quite compellingly. Um, so I just want to note that the one other distinction to make about A1 and A2. I don't want to get too granular about it, but I think it's kind of important to note sort of how people fit into either category is that um, under A1, the requirement is that someone have less than a year to live, and under A2, hospice is a lot shorter than that. Generally, for someone to be hospice eligible, usually they have to have a life expectancy of around 3 to 6 months. Um, so I note that as well. The court also looks to another factor of whether someone's an undue risk of escape or danger to the community. They look at the seriousness of the charge, history of escape, length of time from the last misconduct, criminal offenses that someone might have received while in prison, oftentimes I shouldn't say oftentimes, every time a case is brought, the superintendent of the prison will draft an affidavit where they will weigh in about whether or not they think an individual presents a security risk to the community if they're released. Um, and there might be other specific factors that relate to the case that a court will consider, like proximity to the victim, um, conduct since the offense, and also someone's cognitive abilities. We've encountered a number of people who are suffering from dementia or Alzheimer's, and connecting them to memory care units, I think is another way to sort of address this question. I save that there's a video in here that I'm happy to pass the slides around afterwards so that if individuals would like to watch it, you can. You can't see the picture, I guess, on this, but it's a video with one of our clients, Mr. Bradford Gamble, who had to forego life-saving medical care to be eligible for the medical transfer statute. It's just really it's just really very, very sad and tragic and really gets at why this statute why it's so narrow and how harmful it can be. So Mr. Gamble applied for compassionate release under A2 to receive home hospice. And in order to receive and be eligible for hospice care, he had to have a prognosis that made him hospice eligible. So that meant for his cancer that he had, he couldn't receive curative care. He could only receive hospice care that was palliative in nature. It was his decision, and I think what was very important for him was to use his platform and his decision to try to spread the message of how this statute is anything but compassionate, and how it really um, calls for a repeal of this law and for geriatric parole to get passed. So I think for a lot of individuals who are on this call, you've probably heard of the geriatric parole bill that was proposed. It was in the House. It made it out of the House Judiciary Committee, and that bill actually would repeal the statute and replace it with an opportunity to give a lot more individuals access to parole. So they would still have to appear in front of a parole board. And I'll contrast that with this statute. The medical transfer statute allows someone to petition their sentencing court for relief. So if someone is eligible, they will go to their court of conviction. The president judge will assign a judge, and that judge will hear the case. The proposed law, everything would go through the parole board, and it would open up the class of people who are eligible to a much larger a range of individuals. There's a provision in there for it to address people who are older. So for that itself to be a criteria, and then also for people who are diagnosed with serious illnesses, where there's not, it doesn't necessarily have to be terminal, it just has to be a serious illness for that to be a criteria for the parole board to consider. Oh, so this is his picture. You can see that's Mr. Gamble, and he spent 46 years in prison. Most of the people we've worked with have spent more than 40 years in prison. So I just wrote my email on there, and I also do these cases with a number of other people. A lot of times what we will do is if someone is eligible, we work with some students as well out of the UPenn Law School. They have a compassionate release collaborative. So some students often help us, and we'll draft petitions, and either we will bring them at ALC or we'll try to find referral attorneys to take cases. For a lot of cases that are out of county, we'll try to find attorneys and match individuals with people who might be interested in taking these cases pro bono. And I mean, we're going to stop sharing because those are the end of my slides. But yeah, there's a lot of issues that come up really post release for a lot of individuals. We've connected many people to relief, but there's all these things that the prisons don't help with, like for instance connecting people's family members to advanced planning documents to help them make sure that their rights are protected, to make sure that they're able to get a medical power of attorney or make decisions on behalf of family members when they're very sick. A lot of other issues come up around burial costs. It's very expensive. I'm sure as many of you know, to either have a family member cremated or to have them buried. And there's not really a lot of assistance to help people with that. I mean, when someone passes away who's in prison, oftentimes what'll happen is the money to cover some of those expenses comes out of their commissary. If a family member wants to bury that individual, they have to pay a fee based on how many miles it might be for that person is from the prison. They have to pay like a fee to have their body transported, and then it's really a great expense to then bury them. And then if someone comes home, oftentimes they're left with the expenses, and it's like something that just requires planning, and there's not always a lot of assistance to let people know about what to expect. So there's all kinds of issues that come up, and some people on this call have been very helpful when issues like that come up. Yeah, especially around individuals who might have lost touch with their family members. They might have been incarcerated 45, 46 years, but they haven't been in touch with family. And so being able to connect individuals to nursing facilities that are willing to take them in, also facilities that are able to sort of fill in the gap when family members might have the ability to care, but they don't necessarily have space in their home, or to provide like 24/7 care for individuals. That's been a big help. So, I guess one thing I want to say is that I wanted to sort of like granularly go through what the statute was for anyone who's interested, but on a high level, I mean, it's obviously really apparent that there's so many people who fall through the cracks under this law. There's a number of people we assist and we will bring petitions for, but there are triple as many people who are extremely sick, whose needs are not being met, and who are not eligible for relief under the statute. Where it just really doesn't make sense at all for them to be incarcerated. And it doesn't make sense at all that they don't fit into the really strict confines of the statute. Like there's an individual who's a quadriplegic who just became a quadriplegic. But life expectancy may not be under a year. And it doesn't make any sense that you'd think that this law would, would cover somebody like that, another individual who's blind and who has cancer, whose needs clearly aren't being met by the prison and who you'd think would fall into this statute. But unless your cancer is so far along that you're going to be terminal or hospice eligible, you might not qualify under the statute. So there's so many people that are missed. And the need for a more actually compassionate law is just like is glaring, um yeah, so I would invite anybody here who has questions or wants to talk about any specifics to let me know. I recognize some of your names as people who've also done a lot of work with this exact population, and I'm sure have like a lot of collective wisdom beyond the wisdom that I've gotten from the last like 2 years. So happy to
I have a
answer
couple
questions
written
or also
questions.
hear. Does someone
Um,
say something? Yeah.
I can just read them to you, and then maybe there'll be some follow up. But so this is from Teresa. I'm just gonna go with the first name. Once a judge okays a medical release, can the prisoner be released to a family member with a record? Or if a family member doesn't have a criminal record, what about if there's another person in the home that has a record? And so I guess this is specifically releasing them to like at home hospice.
Yeah. So there's nothing in the medical transfer statute that would prohibit that person from being placed in that home. There's no like home plan review that happens on the medical transfer side where they would say, oh, you can or cannot live with this person. However, sometimes individuals who are on parole have parole restrictions around who they can and can't live with. So there was one time where we encountered the situation where, in an abundance of caution, we wanted to make sure that that person's rights were protected who was on parole. So we were able to get a letter in advance from parole, and then we said, hey, parole board, this person wants to take this person in and care for them their end of life. And the parole board said, absolutely, we have no problem with that. So all that to say, it shouldn't be an issue, but if you're worried about protecting the rights of the person who lives in that residence, that could probably be done through the parole board.
Excellent. I think that pretty much answers it. The next question I have is, does it matter what a person's charge is? Um, Meaning, like, does the charge affect the if they can get a medical transfer or not?
No, it's a really good question because I think there are some jurisdictions around the country where in some states there are some charges you can be convicted of that will preclude you from relief. Like there are some states where if you're charged with murder or if you're charged with a murder of a certain kind of individual, like a protected class, like a cop, that you might not be eligible. However, that's not the case in Pennsylvania. In Pennsylvania, no matter what it is that you're convicted of, you can be eligible for a medical transfer. So there's no exceptions at all for what somebody is convicted of.
And then the last question I have is, are all prisoners released with ankle bracelets?
Yeah, that is also a good question because it's one we have thought about a lot because a lot of individuals we've worked with and clients will experience so much swelling when they're at the end of life that they actually experience like really extreme discomfort from their ankle monitors. So besides the fact that, they seem a bit redundant, for individuals, particularly who are bedridden, we've tried to address this issue. Under the actual statute, the precise language is that someone can have their sentence deferred, which means nothing's happening to the underlying sentence. No one's getting commuted, no one's getting exonerated. It's deferring a sentence. Someone's sentence can be deferred, and if that happens, they will be subject to electronic monitoring. So when you think about what subject to means, I mean, it requires electronic monitoring. The exact language is that someone has to be subject to electronic monitoring. So we have not, I think we have not been able to challenge the electronic monitor because it seems to be required by statute. So there's not really a way for someone to be released without being subject to electronic monitoring. I think maybe an interesting novel argument could be made that the word subject to means it's optional or discretionary, but I know the Department of Corrections disagrees with that and that it would probably be something that would be appealed. So we haven't seen it. And I think, yeah, generally the requirement is that someone would be, um, would have to have an ankle monitor on. Yeah.
Are there any other questions? I don't have any more in the chat. I mean, if there's any final questions.
I would just say also, I don't know if there's any other questions, if anyone has anything else, but if anyone is interested, um yeah, if anyone is interested in collaborating in any way or wants to connect, if anyone's aware of anybody who might be eligible and wants to connect them to legal support, to feel free to reach out. I just put my email in the chat. I'm not sure like all the things that may have brought people to this Zoom or what aspect of this work you might be interested in. I know for some of you guys who are, maybe volunteering, like feel free to be in touch if it seems like there might be ways for us to collaborate. Um, got a nice question from Martha. Shout out to Martha. If anybody wants to volunteer, what kind of help would we need from volunteers? If folks are interested in being engaged with people who are sick and who might need a support system, I think that's something that could be really valuable. I think for some individuals who are coming home who don't necessarily have a lot of family members, sometimes it can be helpful to have other individuals just check up on them, and to sort of like um, just be a part of the community. So if anyone has any interest in that kind of level of engagement, depending on where you are, there's individuals we work with who are in Philly, who are in Pittsburgh. I think that'd be really interesting. We talked about sort of training people to be death doulas and to kind of step in and talk about some of these like hard conversations to help people with end of life planning around around like how people want to transition. And so if that's something anyone's interested in as well, we're trying to sort of meet that gap for individuals who might have like some competency around prison and particularly like what people who are reentering are experiencing. So I mentioned that as well. That's of interest. Yeah, if there aren't any other questions, I just want to sort of
The
thank everyone.
medical
Yeah, go
hearings
ahead.
aren't open to public, are they?
They are. Yeah, they are because they're in criminal court, which is public. So we definitely will invite people to come to some hearings. And that's, I think, another maybe great plug as well. So we could probably let people know when like court support is needed in Pittsburgh for any hearings. I know we've had one in the past where I'm pretty sure I'm pretty sure we had a good turnout at that particular hearing that was in Pittsburgh. So also happy to yeah, make that connection as well for individuals who have hearings in Pittsburgh.
And can they ever be revoked? Like, can this medical release be taken away?
Yeah, it can. Under the statute, there's a requirement that it be done for good cause. So, good cause really should be like a material change in something that wasn't present at the time of the hearing. So, I've never seen it happen. I've never heard of it happening, but it's possible. So, it's just something to be aware of. And I think something people are concerned about because another interpretation of that language could be if someone gets cured and no longer has a terminal illness for whatever reason that they might not then be eligible, that might be a material change. And it's kind of a scary thought. So it's one that I think percolates in a lot of people's minds. And another thing that makes this law, not great. Yeah.
Well, thank you so much, Rupalee. That was all very interesting and educational. Autumn, did you want to say a word before we all? No? Well, Autumn, thanks everyone. I'll be her words. And thank you so much. I'm going to stop the recording now.